The state you trust may not trust you back. If you're leaning on a domestic asset protection trust because your state says it's safe, stay with me, because in the next few minutes, I'll show you why in a serious lawsuit, that promise often evaporates and what actually holds. Hi, I'm Kevin, the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. For 34 years, I've lived in the asset protection trenches, and for nearly 30 of those, I've been setting up Cook Islands Trusts. Our organization has set up more Cook Islands Trusts than any firm in the world. I'm not here to hype you, I'm here to keep you whole. Quick ask, if you want straight practical protection strategies with receipts, tap subscribe and hit the bell. Also, I put a free domestic versus offshore reality check PDF in my website at assetprotectionplanners.com, where you get a lot of free information. It's the same checklist that we use with clients to pressure test a plan. Now let's go to work. Domestic Asset Protection Trust, DAPTs, sound fantastic. A state like Nevada, Delaware, South Dakota, or Alaska says, put your assets here, even if you're also a beneficiary, and after a seasoning period, you're insulated from future creditors. The sales pitch: no need to go offshore. Keep everything convenient. Sleep like a baby. Now here's the reality. Lawsuits aren't polite. They cross borders, exploit exceptions, and weaponize procedure. A DAPT is only as strong as the worst courtroom that touches it. Let me translate that. In day-to-day life, a DAPT might keep nuisances away, the I heard you have money type of claim, but the moment there's a serious injury, a contract blow-up, a professional claim, or anything with a seven-figure cent, you're not in brochure land anymore. You're in a forum where opposing counsel lives to find the zipper in your armor, and they bring friends. Now, in about 3 minutes, I'll reveal the single clause that courts use to reach your protected domestic trust, even when your state swears it's untouchable. Don't miss it. Now, here's the part most brochures whisper past. The U.S. Constitution's full faith and credit clause means a judgment from state A can be recognized and enforced in state B. If a California or New York court decides you injured someone or breached a big contract, the winning creditor can domesticate that judgment in your DAPT state and chase assets. And when a non-DAPT state smells a self-settled trust that looks like you protecting you, public policy kicks in. Many courts view self-settled spendthrift trust as, let's say, optimistic. Add the exceptions: fraudulent transfer statutes, child support and alimony carve-outs, tort creditors in some jurisdictions, and in bankruptcy, Section 548E with a 10-year look back for self-settled trusts. You don't need to memorize the numbers. Just remember the theme. In a serious case, the courtroom tends to prioritize victims and public policy over your in-state paperwork. Okay, now here's the case law you should actually care about. Now, without putting you to sleep, here's the movie trailer version of real outcomes. In multiple cases, courts ignored domestic trust firewalls when the debtor's home state had stronger public policy against self-settled protection, or when the timing smelled like a fraudulent transfer. In some, the judges asserted jurisdiction over the trustee or the assets by leveraging where the debtor lived or where the harm occurred. And when bankruptcy entered the chat, the trust walls got shorter. Bottom line, impressive sounding domestic laws can wilt in hostile soil. Now, in a moment, I'll walk you through a 3-state scenario, a very common profile for our clients, and show you exactly where a domestic plan snaps under pressure. And then I'll show you the version that doesn't snap. Okay, let's call this the 3-state reality test. Scenario: you live in California. Your operating company and rentals are in Texas. You're a DAPT sits in Nevada. A plaintiff wins a big California judgment. So what happens? First, the creditor domesticates the judgment in Texas to reach business cash flow or property. Second, they domesticate in Nevada and argue your Nevada trust is a self-settled device violating California policy. Third, they attack your transfers into the trust as fraudulent because you saw the storm clouds and then move the assets. Each step has a legal pretext and a practical path. path. And here's the hidden danger. Courts can order you to repatriate assets if you control the trustee or the LLC manager downstream. Even subtly. Judges see right through it. Turn it over, they say, and if you refuse, you risk contempt of court. You can't be jailed for owing money, but you can be jailed for ignoring the judge. That's the difference. Okay, that's great, business guy. So what does not snap? A structure where the court can't simply phone a friend and get compliance, where foreign law, not domestic policy, controls, and where your day-to-day control exists only in peacetime. That's the pivot. Okay, now here's what actually works. Enter the modern offshore asset protection trust. The Cook Islands pioneered this field, and they still set the standard. 3 features matter in the real world. Number 1, foreign courts do not recognize U.S. judgments. You must relitigate the case there under local law. The plaintiff's burden of proof is extremely high. Number 3, very short statutes of limitation for fraudulent transfer claims and plaintiff unfriendly remedies. Add significant practical friction, distance, cost, specialized counsel, and bonds. When the road is uphill and covered in marbles, fewer pursuers make the climb. In fact, in the 30 years I've been setting up Cook Islands Trust, not one of our clients' trusts have been breached. Now, layer in governance. The trust appoints a licensed, bonded trustee company law firm offshore with fiduciary duties under that jurisdiction's law, not yours. Domestic courts can shout, but foreign trustees aren't bound by those orders. Meanwhile, you can have day-to-day control through an underlying LLC. In other words, we put an LLC, an offshore LLC, inside of the offshore trust. You're the manager when life is calm. And when it's not, a duress clause forces the trustee to take the wheel and keep the assets out of reach. Now, here's the version we've refined through thousands of clients. A Cook Islands trust at the top. Inside it, a Cook Islands LLC. During peacetime, you manage the LLC. Bank and brokerage accounts or liens and notes from equity stripping strategies sit in the LLC. So in other words, we record liens against all of your real estate and UCC1 liens against your business and all of its assets. That's called equity stripping. When a lawsuit hits, the trust's duress provisions trigger. The offshore trustee, our licensed bonded trustee law firm, steps in and replaces your management temporarily to protect the castle. When the storm passes, you go back to being the manager of the LLC. In other words, it's the same comfortable day-to-day minus the easy button that a U.S. judge presses. And because the trust, LLC, and custodial relationships are properly outside U.S. jurisdiction, a domestic judge can't just fax an order to your bank and vacuum your account. They'd have to go to the Cook Islands court and start over under Cook Islands law. That's not theater. That's the difference between nice plan and real plan. Okay, now in 2 minutes, I'll show you the most common way people think they're using domestic tools safely and how we keep the same convenience without the fatal flaw. Okay, let's talk about the convenience trap and how to avoid it. Now, the convenience trap goes like this. I want everything local trustee, local bank account, local LLC, because I want to see it and touch it. Now, I understand. You're a builder, a doctor, a founder. You like dashboards you can drive. The problem is not the dashboard. It's where the steering column connects. If your ultimate control point is in the U.S., a U.S. judge can order you to steer it into the plaintiff's garage. So here's how we keep convenience using the international structure. We use familiar U.S. operating LLCs for your businesses and real estate. But the safety layer, the trust and its LLC, lives offshore. Day to day, you still bank and invest normally. Your CPA still files the U.S. returns. But the moment somebody files a lawsuit against you, the offshore layer removes the grab handle from the U.S. courtroom. Same dashboard, different firewall. Okay, here's a quick note on real estate. Title rarely moves offshore. Instead, we use equity stripping, perfectly legal liens recorded against the properties in favor initially of the offshore LLC. Sometimes, if needed, with a third-party lender buying those notes for added separation and placing the proceeds into your offshore trust. Plaintiffs chase equity. We move the cheese. Okay, now let's take a look at some case studies so this all comes to light. Case study A, the contractor with the 8 figures in risk. A general contractor in the Southwest had $8 to $10 million in net worth, equipment, and a couple of apartments. He picked a domestic trust because a buddy swore by it. Then a crane accident injured a subcontractor. The plaintiff's counsel won a verdict in a non-DAPT state, domesticated it where his rental sat, and challenged the trust under fraudulent transfer principles. Our team was hired after the punch. Couldn't unring the bell domestically, so we built an offshore trust and an LLC, moved the liquid assets offshore, and executed liens on the rentals. The case didn't vanish, but the leverage did. It settled on terms that preserved his family's future. Okay, now case B, the physician with anesthesiology exposure. A physician with $3.2 million liquid and a partnership K1 used a domestic plan. A freak outcome led to a claim and a stubborn plaintiff. Domestic charging orders sounded comfortable until the plaintiff used supplemental proceedings to pressure distribution. So we converted to a Cook Island structure, opened an offshore account for the LLC, and tightened governance with a rapid duress protocol. Negotiations changed tone. Money moves when leverage shifts. Okay, case study C, the tech founder after a down round. A founder with $12 million, half liquid, half rentals, faced a co-founder dispute with a forum shopping adversary. We implemented the offshore trust in the LLC well before the dispute ripened, documented solvency and legitimate estate planning moves, and then we executed equity stripping liens on the rentals. So when the dispute exploded, the other side bluffed about piercing everything. Our response? Great, see you in Rarotonga. They settled for control of the company IP while our client kept the personal nest egg. Now keep in mind that timing matters. Courts hate eve of trouble transfers. Build in peacetime. Document real non-creditor motives. Estate planning governance, international diversification, succession, and risk management. Show that you were solvent after funding the trust. Keep clean KYC and AML files, valuation memos, and minutes. If the court ever reads your documents, let them read a grown-up plan, not a panic diary. Okay, now let's talk banking optics. Offshore does not equal spooky. We use banks that are KYC heavy and regulator friendly. Wires are transparent. Your CPA gets 1099s or the equivalent statements. The narrative? You professionalized risk, not that you ran to a secret island with a backpack of bearer bonds. Okay, now here's a tax note. An asset protection trust for U.S. persons is typically tax neutral. You still report, you still pay. The protection is legal separation and foreign jurisdictional control, not tax evasion. Say it with me. Control when calm, distance when sued. All right, now in a minute, I'll give you the 2 questions that every serious plaintiff's lawyer asks in the first weeks of a case and how to make both answers useless to the plaintiff. All right, question 1. Where's the cash today? If the answer is a U.S. bank titled to my name or my domestic trust, that's a laser pointer for a turnover order. Make the answer boring. Diversified custodians, including foreign custody held by an offshore LLC. Not illegal, just not collectible with a phone call. Question 2, who can I pressure? If the answer is you, your spouse, your local trustee, or your friendly banker, you're on the hook. In our structure, pressure points sit where U.S. pressure doesn't travel. Your offshore trustee's legal duty is to protect the trust under foreign law. They don't work for your adversary or for a distant judge. Okay, now here's some domestic tools that still matter. So does this mean that domestic planning is worthless? Not at all. We love LLCs for operating businesses and syndications. We love land trusts for anonymity on title. We love properly structured charging order jurisdictions for business interests. Use domestic entities for business function and privacy. Use offshore trusts for existential defense against personal catastrophic claims. Horses for courses. Okay, here's your implementation roadmap. Step number 1, risk triage. Identify plaintiff magnets, liquid accounts, brokerage distributions, and real estate equity. Okay. Step number 2, so make that list. Establish the Cook Islands Trust and its LLC inside of it. Step number 3, open custodial relationships, domestic and foreign, for diversification. Step number 4, title or pledge liquid assets to the LLC. Execute equity stripping on real estate with recorded liens and, where appropriate, third-party note purchases with the proceeds going into your offshore trust. Step 5, document governance, solvency, and the duress protocol. Step number 6, maintain annual minutes, KYC, AML, that's anti-money laundering, updates, and quiet competence. And the nice thing, you can talk to our team. We do this all every weekday. Okay, now here's some common mistakes to avoid. Funding after demand letter. Now, courts smell that from a mile away. There are ways we can protect you after you've been challenged, but it's best to do it as early as possible. Next, keeping U.S. control levers. Local trustee, domestic manager connected to the assets. Next, assuming a charging order is a force field for personal assets. It's not. Next, titling real estate offshore instead of using liens. That invites tax, lender, and practical problems. Next, failing to train your team. Your controller wires money from the wrong account under duress. You've defeated your own plan. Okay, now let's answer the common myths. First of all, my accountant says offshore is a red flag. Good accountants like documentation and predictability. We provide both. Won't a judge throw me in jail? Well, judges can order repatriation, but the structure removes your legal ability to comply during duress. Courts don't punish the impossible, only the disobedient. Okay, next one. Isn't this just for billionaires? No. Our typical client is a business owner or professional in the $500,000 to $20 million range who wants to keep what they've built. Okay, so why us and why now? The answer is I've been doing this work for 34 years, nearly 30 with Cook Islands Trust, and our organization has set up more of them than any firm in the world. That matters because details matter. Banking relationships, trustee response time, duress choreography, and the judgment of when to move and when to hold. You want a team that's rehearsed the fire drill 1,000 times before your alarm goes off. Okay, here's what to do next. First of all, download the free domestic versus offshore reality check in the description or at assetprotectionplanners.com. Use it to pressure test your current plan. Second, schedule a confidential consultation at assetprotectionplanners.com. That is, if you're serious and not just curious and you have $500,000 or more in assets to protect, we'll help you decide if you're fine, need a tune-up, or need a full offshore firewall. If you wait until after a claim, you've handed your opponent the timing advantage, so don't do that. So finally, if you found this valuable, subscribe so you don't miss the advanced playbook videos we've got coming. I'm the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. The state you trust may not trust you back, but your plan can. I'll see you in the next one.